Welcome to literary and jury charge practice. Let's get started with some jury charge practice. And the subject of this jury charge is mental incompetency to contract or to contract. Mental incompetency to contract. Ready? Here we go. Members of the jury, there is the second defense here that Joseph Briggs was incompetent and that he was easily influenced. There are a great many men who are easily influenced and a great many men that nobody can influence, but they are all capable of doing business unless they are so incompetent that they do not understand the nature of the transaction. Men who are easily influenced and have money generally lose it, and the public and those who deal with them are not bound to be their guardians if they deal in good faith. If Mr. Foster paid this money in good faith to Mr. Briggs, he is entitled to recover it unless Mr. Briggs was so incompetent that he didn't understand the nature of the transaction and didn't know anything about what he was doing. If he had a reasonable acquaintance with the nature of borrowing money and giving a note for it, he could handle his own business and be bound by it until he was declared incompetent by some proper court and put under guardianship. Now was he in such mental condition at the time that he gave this note as not to be capable of understanding the nature of the transaction? It does not make any difference if he was afterwards declared incompetent. The examination that was mentioned here was after the date of the transaction and would not affect any date before that time. The fact that a man is declared incompetent today by a court does not show that he was incompetent yesterday or at any time previous. It is for you to say here now as a jury on the evidence presented to you whether Joseph Briggs was at the time he accepted money from Harry Foster in such a disturbed mental condition that he didn't understand the nature of the transaction. All right, now for some literary practice. This is called nervousness and test taking. Ready? Here we go. How do you get over nervousness when taking tests? This question was asked on the NCRA online forum and several people responded with advice. Teresa Van Meter, RMR, CRR of Clarksville, Tennessee replied, "My personal strategy that has worked for me is to be at or near the next highest speed from the exam. For example, when I took the RMR, I practiced until I could nearly write 280 words per minute. That helped tremendously because I knew I could write faster than the test speed. There could be short 3 to 4 second bursts during an exam that are actually faster than speed. When you're trying to get every stroke perfect so you can write that test up, your speed will slow down a little. I think a little extra speed is crucial when it comes to nerves and test taking." A valuable piece of advice I got from Mark Kislingbury, RMR, CRR of Houston, Texas, was to practice at the higher speed before the exam as much as possible and then to not write the 1-minute warm-up that is given before the test. I practiced in the next room until I had to go into the exam room. Then I just didn't write the warm-up. My fingers didn't get used to moving at that slower speed. When I passed the RPR right after court reporting school, I pretended I was taking a job and my backup audio wasn't working, so I had to get every word. It was a little mind game, but it seemed to work for me. Catherine A. Thomas, RMR of Caseyville, Illinois, wrote, "I don't write the 1-minute warm-up either, and yes, practice faster material." If I remember correctly, Mark Kislingbury's rule of thumb is 25% faster, which I did, and no, I didn't get all of it, but the test itself then seemed so slow, and once the voices of "Hey, this seems so slow" started talking, I just had to shut them up and ignore the shaking hands. Once my shaking hands know I'm not paying attention to them, they stop shaking. Anthony Frieselone, RDR, CRI of Staten Island, New York, wrote, "My strategy for overcoming test nerves is practicing every day for an hour and 15 minutes. The first 15 minutes is the test. I always use fresh material, RPR or RMR. Then I transcribe the tests and I go over them to look for errors and trouble spots. I think simulating the testing environment is the key to successfully decreasing test nerves. I try to practice early in the day to simulate the early morning testing. Meditation and exercise also plays a big part in my practice routine. I find a time in the day, usually morning, and I meditate for 15 to 20 minutes, visualizing myself taking the test and seeing a successful outcome. I exercise 4 days a week to help work off the stress of preparing for the test and fitting in my practice routine with my work schedule. Also, as a chief examiner, it is my goal to make the testing situation for the candidate as stress-free as possible. That usually starts at the front door with my greeting the candidates and addressing the candidates by their first names. After giving the candidates sufficient time to set up for the test, I come in to answer any questions they may have. I also try to make some jokes and keep people laughing and smiling. Right before I begin, I tell them that they're doing a great thing and that they should be proud of their dedication to the profession. In a similar thread, Julia Bammel of Shelby Township, Michigan, wrote, "I hold a CSR, but I desperately want my RPR so that I can expand my options on work opportunities in different parts of the country. Like so many others, I fall victim to nerves. My hands shake so badly I have had a hard time keeping them on the keys. I finally solved the sweaty hands problem with leather key tops. For the past several months, I have been drilling high-speed tapes and CDs just like I did in preparation for my CSR. Sadly, even when I do a sample test at home, I still get shaky hands and bomb the test. I'm going to treat the RPR like a deposition and see if that helps. Anyway, the thing I noticed in my deposition today is that just signing up for the RPR has made me a better writer because I'm practicing so much more than I normally do. I took medical testimony today, which I usually struggle through, and it was a piece of cake. I guess the point I'm trying to make, at least to those who don't already know it, nothing but good can come out of signing up for certification exams. As badly as I want the RPR, I know that if I don't pass, by the time the test rolls around again in November, the extra 6 months of high-speed practice will have made me a better reporter." Now back to some jury charge. This is called Attorney and Client. Ready? Here we go. Ladies and gentlemen of the jury, an attorney at law, when retained by another, is entitled to fair and reasonable compensation for the professional services rendered. There is no fixed standard by which the value of the services of an attorney can be determined. His value and reasonable price necessarily vary with the magnitude and importance of the particular case, the degree of responsibility attaching to the work performed, the difficulty of the matters involved, the time consumed, and the benefits derived. In ascertaining the value of such services, you will exercise your sound discretion and judgment and allow such reasonable amount as you believe constitutes a just and fair compensation for the services rendered not to exceed the sum of $3,000. In determining the value of the services rendered, you may take into consideration the fact that at the time of undertaking the work, the attorneys bound themselves to make no charge for their services if they fail to secure beneficial results. The fact that these services were to be rendered on a contingent fee basis, which means that no charge was to be made unless beneficial results were obtained for the defendant, should be considered by you in determining the value of the services. It is customary for attorneys to charge more than they undertake to render professional services on a contingent fee basis because under such a contract, no charge can be made unless beneficial results are obtained, no matter how much actual work may have been performed. You are instructed that the mere fact, if it be a fact, that the litigation did not result to such advantage to defendant as he may have hoped it would, does not preclude the right of plaintiffs to recover in this action. If the defendant employed the plaintiffs to prosecute the suit in question, the plaintiffs are entitled to be paid for their services. To some literary material. Ready? Here we go. What I don't understand, though, is how I can walk into an adversarial environment filled with fast-talking attorneys and mumbling witnesses and feel totally calm and able to do my job and yet get so nervous at test time. In both cases, it's imperative that I get all the words, and yet in this setting where I should feel more pressured by the circumstances, I'm totally at ease, but in a controlled testing environment, I'm a wreck. I just don't get it. Candace Bradshaw of Hummelstown, Pennsylvania wrote, I think the biggest thing is that we psych ourselves out about the test. We know we have the ability to take the test and ace it, but we get into the test freak-out mode and freak out because it's a test. I also think that we all try to be perfectionists on speed tests and get copper plate notes, and we let our inner voices, for example, I'm getting this, shoot, how could you have missed that word? How do I stroke golf? What was that word? Get in our way. I don't think our regular jobs help us conquer these inner voices enough, and most of us don't spend time conquering the voices away from the job in practice. I try to get my mental stuff together before tests instead of trying to write speed tapes and finally freaking myself out. I listen to faster tapes as I'm going to the test site and imagine myself getting every word down perfectly. Once at the test site, I do some very basic warm-ups, finger drills, running the alphabet, but I spend the bulk of my time getting myself in the right mental frame of mind. If you don't have the speed and accuracy when you're driving to that test site, you're not going to get it before the test. Kind of the same analogy as a musician practicing too much right before a big concert or audition. Any good musician knows you won't learn your part in the warm-up before a concert or audition. As a matter of fact, mistakes you make in warm-up can mess up your performance. Thomas wrote back, something I've been doing for ages. I took the RPR 7 times before I got it, and successfully tried the CRR twice, and I'm facing my third attempt at the RMR. Is not writing the 1-minute practice dictation. I sit with my eyes shut and see what every word looks like on the steno keys. When I do this instead of actually writing, it has helped to calm those voices. That warm-up was so hard, or what am I thinking trying this test, or that warm-up was so easy. I'm going to ace this, there goes a drop, and just gives my brain a head start at being quiet. All right, back to some jury charge. And this jury charge, the subject is contributory negligence. Ready? Here we go. Ladies and gentlemen of the jury, contributory negligence is a want of ordinary or reasonable care on the part of the person injured by the negligence of another, directly contributing to the injury as a proximate cause thereof. Contributory negligence may also be defined as a failure on the part of a person injured by the negligence of another to exercise ordinary or reasonable care to avoid the injury. One cannot recover damages for an injury to the commission of which he has directly contributed. If the passenger is at fault, whether because of doing something he should not have done or in failing to do something he should have done, then he cannot recover any damages for injuries he has sustained. If the passenger's negligence has been a proximate cause of his injuries, he cannot recover from another who has also been negligent. But before you can find that the plaintiff is barred from recovery because of his own contributory negligence, you must find that his negligence was a substantial factor which, together with the defendant's negligence, proximately caused the accident. If the plaintiff, in the exercise of ordinary care under the circumstances, should have been aware either that the defendant was unmindful of some danger known or apparent to the plaintiff, or that the defendant was not taking proper precaution in the operation of the car, and the plaintiff failed to admonish the driver or failed to take proper steps for his own safety, and if such failure to admonish the driver was a substantial factor in proximately causing the accident, then the plaintiff cannot recover, even though the driver was negligent. But if you find from the evidence that as the car in which plaintiff was riding approached the place of the accident, the plaintiff exercised a care that a person of ordinary prudence and care would have exercised under the same circumstances with regard to admonishing the driver, then the plaintiff was not guilty of contributory negligence. The burden of proof rests upon the defendant to prove by the preponderance of the evidence that the plaintiff was guilty of contributory negligence, and if on this question you find the evidence evenly balanced or preponderating in plaintiff's favor, then you will find that the plaintiff was not negligent. Ready? Here we go. The defense attorney used charts to show the times that the defendant had been speaking to someone. The exhibit charts prepared by the defense attorney's office were very good. They presented a story that any normal person would be able to understand. They hoped that this time chart would free the defendant. The tangible evidence that the prosecutor's office had was not good. No prudent person would be able to say that the defendant was guilty based upon this evidence. No prudent person would be able to say that the defendant was guilty based upon these exhibits. Other than this tangible evidence, no other evidence was revealed. The arguments presented by the prosecutor were not very good. The prosecutors tried to show that the defendant committed the crime of murder. They tried to prove that there was evidence that was really good that would prove that the defendant was guilty of the crime for which he was accused. Insanity is a defense that is sometimes used. It is based upon the principle that a defendant should be punished for a crime only if he is able to understand what he did. It is based upon the principle that the defendant is someone who knows right from wrong. In many states, if people are suffering from a mental disorder, the question is whether they can know right from wrong. The insanity defense prevents individuals from being criminally punished. There are many questions that arise from the insanity defense. One of the questions is whether it is possible for a person to judge whether another person really suffers from a mental disorder. It is a difficult judgment to make. It involves getting opinions from experts on both sides. This process takes time. It is questionable whether anyone can determine whether another person is suffering from a mental disorder or is faking it. Generally, it is thought that many people use the insanity defense to get out of being punished from a crime, but that is not so. The process is so involved that it often prevents individuals from using it. Most people think that the defense of insanity is used a great deal. The insanity defense is not used as much as is thought. The reason is that using the defense requires that a person subject himself to a number of tests. It may involve other things. Finding a person guilty by reason of insanity may result in a longer period of time locked up in a mental institution than would the sentence be for the crime. That is something that the defendant has to consider. The law defines insanity in many ways. In some states, the law is that anyone who is suffering from a mental disorder is deemed to be insane. In other states, the rule prevails in which the defendant is said to be insane if he is not able to tell the difference between right and wrong. Various ways of defining insanity are used because there has been no standard way of doing it. The most commonly used law is defined as the law is referred to as the right or wrong rule. It defines insanity of the inability to tell right from wrong. There are many other tests for insanity. One common test is to determine if a person knew an act to be wrong, but because of his mental condition could not control his actions. This is one way of describing it. Another common test: defendants found not guilty by reason of insanity are not set free. They are usually confined to a mental institution until they are determined to be sane. They may be confined for a longer period than if punished in another way. An insanity defense normally rests on the testimony of someone who testifies for the defendant. All right, that will conclude our literary and jury charge practice.